Here we go. Mr. Minister Bennett for Mr. Lametti, seconded by Madame Bibeau, moves that Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act, be now read a second time and referred to the Standing Committee on Justice and Human Rights. Debate the Honourable Parliamentary Secretary to the Minister of Justice.
Thank you, Mr. Speaker. I am delighted to join you this morning to speak on Bill C-5, an act to amend the Criminal Code and the Controlled Drugs and Substances Act. And I want to acknowledge that we're gathered here on the traditional unceded lands of the Algonquin and Anishinaabe peoples. Mr. Speaker, this bill fulfills a platform commitment to reintroduce former Bill C-22 within 100 days, and I'm proud to work with the Minister of Justice on this important piece of legislation. The proposed reforms represent an important step in our government's continuing efforts to make our criminal justice system fairer for everyone by seeking to address the overrepresentation of Indigenous peoples, Black Canadians, and members of marginalized communities. Bill C-5 focuses on existing laws that have exacerbated underlying social, economic, institutional, and historical disadvantage, and which have contributed to systemic inequities at all stages of the criminal justice system, from first contact with law enforcement all the way through sentencing. La question de racisme est...
Questions of racism and systemic discrimination in the Canadian criminal justice system are well documented, including by commissions of inquiry like the Truth and Reconciliation Commission, the National Inquiry into Missing and Murdered Indigenous Women and Girls, and the Commission on Systemic Racism in the Ontario criminal justice system.
More recently, the Parliamentary Black Caucus, in their June 2020 statement, called for reform of the justice and public safety systems to weed out anti-Black racism, systemic bias, and to make the administration of justice and public security more reflective of and sensitive to the diversity of our country. I was pleased to sign this statement, as were numerous cabinet colleagues, including the Minister of Justice and many members of Parliament, as well as senators representing the different political spectrums. The numbers speak for themselves, Mr. Speaker. Black Canadians represent 3% of the Canadian population, yet are represented by 7% within who are those incarcerated in federal penitentiaries. Indigenous people represent roughly 5% of the Canadian population, yet represent 30% of those who are federally incarcerated. And that is profoundly more for Indigenous women, who represent 42% of those who are incarcerated. Madam Speaker, Indigenous people as well as Black Canadians have been particularly marginalized by the current criminal justice system. These calls for action have recognized that sentencing laws, and in particular the broad and indiscriminate use of MMPs, mandatory minimum penalties, and restrictions on the use of conditional sentences, have made our criminal justice system less fair and have disproportionately hurt certain communities in Canada. This is precisely why Bill C-5 proposes to repeal a number of mandatory minimum penalties, including for all drug-related offenses and for some firearm-related offenses. Although some MMPs would be retained for serious offenses such as murder and serious firearm offenses linked to organized crime, data shows that MMPs that would be repealed have particularly contributed to the over-incarceration of Indigenous peoples, Black Canadians, and members of marginalized communities. This bill would increase the availability of conditional sentencing orders in cases where offenders do not pose a risk to public safety. CSOs allow offenders to serve sentences of less than 2 years in the community under strict conditions, such as house arrest or curfew, while still being able to benefit from employment, educational opportunities, family ties, and community and health-related support systems. Madam Speaker, I want to talk to you about who we want to help with Bill C-5. The grandmother who agrees to let her grandson leave a gun at her house overnight, even though she knows she isn't supposed to, and when she knows that he didn't purchase the gun legally. The young Indigenous man who shoots a hunting rifle at what he believes to be an empty building. No one gets hurt, and the incident prompts him to get his life back on track. He goes into a rehab program to get off drugs and starts counseling to address childhood and intergenerational trauma that has haunted him throughout his young life. By the time of sentencing, he has a job, a new relationship, and is ready to contribute positively to this community. These are not the hardened criminals. These are people who deserve a second chance or an off-ramp from the criminal justice system. People who, with the right support, will never offend again, sending them to jail, which hurts not only them, but their families and communities, will do nothing to put them on a path but towards further criminality. Madam Speaker, this is why MMPs that tie judges' hands can lead to negative outcomes in the justice system and for our society more broadly. In order to appreciate the pressing need for these reforms, we must go back to the foundational principles of sentencing in Canada. The fundamental purpose and principles of our sentencing regime are rooted in trailblazing reforms made in 1996, which created a statutory recognition that sentencing is an individualized process that relies on judicial discretion to impose just sanctions. Such sanctions are proportionate to the degree of responsibility of the offender and the seriousness of the offense. To achieve these sanctions, the 1996 reforms directed judges to take into account a number of sentencing principles, including rehabilitation and deterrence. Some of these principles acknowledge that in sentencing less serious crimes, imprisonment is often ineffective, unduly punitive, and to be discouraged. The sentencing principles also recognize the need to address the over-incarceration of Indigenous persons who were, at that time, already overrepresented within the system. As such, the amendments to the Criminal Code directed judges to consider all sanctions other than imprisonment that are reasonable in the circumstances before choosing to send an offender to jail. This principle applies to all offenders, but requires judges to pay particular attention to the circumstances of Indigenous offenders. To give full effect to these principles, the 1996 reforms created conditional sentences of imprisonment that allowed judges to order that terms of imprisonment of less than 2 years be served in the community under certain conditions. An offender could be eligible for a conditional sentence if serving their sentence in the community would not pose a risk to public safety, that the offense for which they were convicted is not subject to a mandatory minimum penalty, and that the community-based sentence would be consistent with the fundamental purpose and principles of sentencing. Unfortunately, the previous Conservative government's increased use of mandatory minimum penalties and imposition of additional restrictions on the availability of conditional sentencing orders have restricted judicial discretion and made it difficult for courts to effectively apply these important principles. These so-called tough-on-crime measures have actually made our criminal justice system less effective by discouraging early resolution of cases. These measures have eroded public confidence in the administration of justice. Les conséquences,
By far the most problematic consequence of these sentencing laws has been their disproportionate impact on Indigenous peoples, Black Canadians, and members of marginalized communities.
The Ontario Court of Appeal has recently found in its 2020 decision in R.V. Sharma that certain of the limits on conditional sentence orders enacted in 2012 undermine the purpose of the Gladue principle by limiting the court's ability to impose a fit sentence that makes the offender's circumstances into account. The Court of Appeal held that those limits perpetuate a discriminatory impact against Indigenous offenders in the sentencing process. By targeting these sentencing policies, Bill C-5 seeks to restore the ability of courts to effectively apply the fundamental purpose and principles of sentencing and ensure that sentences are individualized and appropriate for the circumstances of the case. Although it is important to ensure that fair and compassionate sentences are imposed, it is equally important to ensure that measures are in place to avoid contact with the criminal justice system in the first place. This is the reason why Bill C-5 would require police and prosecutors to consider alternatives to laying or proceeding with charges for the simple possession of drugs, such as issuing a warning, taking no action, or diversion to addiction treatment programs. We want to focus on getting individuals the help they need, whether that be treatment programs, housing, or mental health support, instead of criminalizing them. These measures are consistent with the government's public health-centered approach to substance use and the opioid epidemic in Canada. Together, these measures would encourage responses that take into account the individual's experience with systemic racism, health-related issues, and the particular supports they could benefit from. These reforms would allow police, prosecutors, and the courts to give full effect to the important principle of restraint in sentencing, particularly for Indigenous offenders, and explore approaches that focus on restorative justice, rehabilitation of the individual, and the reintegration of them into the community. Il est essentiel que le Canadien
It is essential that Canadians have confidence that the justice system is there to protect them, not to harm them or their communities. These reforms reflect what we have heard from Canadians.
The 2017 National Justice Survey revealed that Canadians overwhelmingly support diversion measures, less restrictive sentences, and judicial discretion in sentencing, even cases where there is an MMP. For instance, 91% of Canadians indicated in the survey that judges should be granted flexibility to impose a lesser sentence than an MMP. Moreover, 69% of those polled believe that diversion could make the criminal justice system more effective, and 78% believe that diversion could make it more efficient by reducing a caseload for the courts and court processing time. I would also like to assure my colleagues that our government takes violent gun crimes seriously. I'm from Scarborough, a community which has issues with gun violence. I understand the need to crack down on firearm traffickers and organized criminal element that threaten our communities. In my previous life, I ran a youth organization and saw many young men who were buried as a result of gun violence. I saw the pain in the faces of the parents. In fact, I recall one mother whose son was killed over 20 years ago, who's still grieving for her loss. This affects the community as a whole, and that is why we're not repealing MMPs for those offenses. I had a chance to speak to Louis March from the Zero Gun Violence movement this morning. He's someone that has advocated for guns to be taken off our streets. He came to Parliament about 2 years ago, just before the pandemic, to advocate for MMPs to be removed because he felt the need to have judges having discretion over decisions is so crucial, and MMPs have disproportionately impacted members of the Black community. Many of the mothers that came here that day were so broken by what they saw was the problem with guns. And I bring this to Parliament each and every day, Madam Speaker. The issue of gun violence is in many ways in Toronto and other major cities a significant problem that requires a significant response, and our government is working towards that. But for less serious offenses, particularly where the offender is a first-time offender, young or nonviolent, MMPs are not the answer. MMPs that send young Black men in my community to prison when they could have been rehabilitated and turned their lives around, only serves to continue the vicious cycle that leads to involvement in gangs and further criminality. We are repealing the MMPs for robbery and extortion with a firearm and discharging a firearm with intent or recklessly that do not involve a restricted firearm or organized crime. In other words, where the offender...
Sorry, I do apologize for interrupting the honourable member, but I do want to remind the official opposition that they will have an opportunity to not only ask questions and comments, but also to debate the issue. And so I would ask them to hold off on their comments while the Honourable Parliamentary Secretary is speaking. The Honourable Member, Parliamentary Secretary.
Thank you, Madam Speaker. In other words, where the offender uses a firearm that may be otherwise legal. A review of the case law reveals that many Indigenous offenders and marginalized groups who have experienced significant trauma, including the legacy of residential schools, commit nonviolent offenses using long guns. Maintaining the 4-year mandatory minimum penalties that relate to the commission of these offenses with firearms that are not restricted or connected to organized crime would directly undermine our important commitment to reducing the over-incarceration of Indigenous peoples. We know that Canadians are troubled by gun violence. By maintaining the MMPs for serious offenses using restricted firearms or in association with organized crime, we keep the strong tools in our toolbox to combat serious and gang-related gun crime. Our government will also work to crack down on gun crime in other ways. In our platform, we committed to continuing to combat gender-based violence and fight gun smuggling with measures we have previously introduced, such as increasing maximum penalties for firearms trafficking and smuggling from 10 to 14 years imprisonment, lifetime background checks to prevent those with a history of abuse against their spouse or partner from obtaining a firearms license, red flags that would allow immediate removal of firearms if that person is a threat to themselves or otherwise to their spouse or partner, and enhancing the capacity of the RCMP and the Canada Border Services Agency to combat the illegal importation of firearms. Our government is taking steps to ensure that the strong hand of criminal justice is used where it is needed to keep people safe, but not where it would discriminatorily, not where it would be discriminatory or counterproductive. Bill C-5 is an important step taken by our government to address the injustice of systemic racism in our criminal justice system and to ensure that it is fair, just, and compassionate for all Canadians. Thank you, Madam Speaker.
Questions and